Morning, Mark.
Morning. How are you doing?
I'm good, thanks. Right, so we've got we've got a response from our initial letters from Maldon District Council.
Yeah.
It's quite an interesting response. What I'm going to do is, shall I read it quickly then, Mark?
Yeah, I think just go through all of the responses and because this is the most comprehensive. Other ones have just got bits and pieces of what's included in there.
Yeah. Okay. All right, so thank you for your recent correspondence in relation to your liability to pay council tax. As per my previous correspondence of 6th of April 22, the legal position you are stating is incorrect. Okay, so your statements do not set out any structured legal arguments. You appear to be suggesting that consent is required by you for council tax to be payable. So she goes on to say, council tax was created by Parliament through legal statute, and liability for this arises under the provisions of the Local Government Finance Act 1992 and subsequent regulations. The tax is payable by whoever is the liable party, which is determined by reference to the legislation mentioned above. There is no legal principle that you are required to consent before being bound by the laws made by Parliament. The arguments you have made are what was referred to in the case of Meads versus Meads by the judge as organised pseudo-legal commercial argument litigants, or OPCA. Very interesting. Due to a common thread of the arguments made by these litigants, all being of a similar nature, specifically that in order to be bound by the law, you have to explicitly agree to it, akin to entering a commercial contract. Right, the principle underpinning our constitution is that Parliament is sovereign, which can make or unmake any law it wishes. See among other sources, the Bill of Rights 1988-9, the Acts of Settlement 1701, we'll go through that in a minute, the Claim of Right Acts 1689, the Acts of Union 1706 and 1707. If any law of Parliament could be defeated just by saying I do not consent, this would defeat any laws passed by Parliament. Sorry, I have to laugh, Mark.
I know, you can't make this stuff up.
You really can't. Whether you are of free body, God-made, or any other that you use, your consent is not required to be subject to acts of Parliament as set out above. Right. So Maldon District Council does not recognise the notices that you have provided. These have no legal basis, and indeed the website that they have been copied from advised you to seek your own legal advice.
At least she's gone to the effort to find us.
Well, you know. You also appear to have misunderstood the term common law. Common law is the development of the law by the higher courts. It fills the gaps between legislation made by Parliament. Parliament is sovereign, again she quotes, meaning that legislation enacted by Parliament takes precedence over previous court decisions, common law, and courts are required to interpret existing common law principles consistently with legislation. Right, so coming to an end, your statements in relation to pre-action protocols appear to confuse the law relating to contracts and alleged rights under common law with the legislation relating to common council tax. Your liability for council tax arises under the Local Government Finance Act 1992 and the subsequent regulations. It is not contingent upon either your consent or the existence of a contractual relationship with the council. Your assertion that the absence of consent or a contract precludes your liability to council tax is incorrect in law, and there is no legal basis upon which to make such an argument. Further to my previous correspondence, I again must state that as an occupier of the property, you are liable for council tax. You advise the council of your occupation of September 19, as the party in occupation, you meet the requirements of S6, Section 6 of the Local Government Finance Regulations and are therefore liable for council tax as part of these regulations. The council will proceed against any party for non-payment of council tax if it remains unpaid. You will have the opportunity to place any arguments before the court should you wish. I would, however, strongly urge you to seek legal advice prior to such a hearing. The council has clearly set out the legislative grounds on which your liability arises on 2 occasions. It does not intend to enter into any further correspondence on this matter. I would strongly suggest you seek legal advice on this matter before taking any action. Thanks for reminding me twice on that. Yours sincerely, Emma Holmes. She is the Senior Specialist Legal of Maldon District.
The guest forgot the top dog here. You should know what they're talking about.
She should basically know what she's talking about. Yes, but it's going to transpire that she's making a lot of claims herself in this.
Yeah, assumptions, presumptions, the usual thing.
And well, Mark, you've gone through the whole lot. You've read Mead versus Mead.
Yeah,
it's a brilliant judgment.
Absolutely brilliant judgment.
For sorts of different reasons. So we're
and just in summary, guess what? If you tick the numbers, the boxes, what she's actually said in her letter ticks more boxes of OPCO litigants than we do.
Yeah, exactly. Yeah, it's
you can't make this stuff up.
It's unbelievable, isn't it? And she, you know, when these people are writing these things, they can't see it from any other perspective apart from, you know.
I mean, the first thing though that comes out, okay, there's this difference. She does use 2 different words, legislation and law.
Yes,
that's one thing, and it's clear that she has no understanding what's the difference between legislation and law.
No.
And so if we just look at the other one, that actually quotes a case. So at least the other council has made an attempt to rely. It understands the difference between law and legislation, and that law is created in courts, as opposed to legislation, which is created by Parliament.
Yeah.
So do you want to just bring that one up, just so that people can see, because that covers the full range then of all of the responses that we've had from the councils. There's nothing beyond anything that is in Maldon's, in Emma's one, and the one from Cornwall Council.
Right.
And so then we can go on paragraph by paragraph to look at what they're saying.
Yeah. Just good.
Like I said, if you just scroll to the top. So this is Cornwall Council, okay? And this one here's got a different response. So if you just scroll down to the bottom of the first page, so it's the usual thing about Local Government Finance Act. And then just scroll down a bit more so that we see, in fact, you might be able to get on one screen. Keep scrolling. So bottom of that one. Okay, whoops, so that we can see what's on both pages. So they're highlighted yellow. So just put courts to the bottom of the page. Okay, that's it. Right. So basically with Cornwall Council, we actually see that they do acknowledge there's a difference between law and legislation, and they actually understand law is created in the courts as opposed to legislation, which is created in Parliament. So what they were trying to argue is this question of parliamentary sovereignty. And they pulled up this case from 1968, Cheney versus Conn, Inspector of Taxes. So the supremacy of Parliament was what was being argued against. And so on the second page, so the bottom part, it says, what the statute itself enacts cannot be unlawful, because what the statutes say and provides is itself the law, and the highest form of law that is known in this country. It is the law which prevails over every other form of law, and it is not for the court to say that a parliamentary enactment, the highest law in the country, is illegal. Therefore, the courts have confirmed that statutes overrule common law, and statutory provisions are enforceable by the courts. So here is a judgment from the court itself back in 1968 saying, no, Parliament is sovereignty. We are mere puppet masters. We do whatever Parliament tells us. That there totally obliviates the whole point of checks and balances, because what this is saying is Parliament can do what it wants, i.e. it's a dictatorship. And begs the question, what about the separation of powers? And thirdly, why do we even bother with courts of law if we must do what Parliament tells us? Right. So you can see the total irrationality of the concept of parliamentary sovereignty. And this judgment we rebutted with the Boris Johnson judgment from 2019, which says the courts are the judges of unlawful actions or not. And with judicial review, basically, that is all about determining whether a decision or an action by those governing is unlawful. So, which, you know, their claim or their side is very, very simple. Legislation equals law. Therefore, they have the right, 650 people in Westminster have the right to create duties, rights, and obligations on the whole population of 67 odd million. Yeah. Which itself again goes against the absolute fundamental principles of law. All are equal under the law. Nobody's above the law. Therefore, how can 650 people in Westminster create duties, rights, and obligations on the population? Huge, massive problem we have. And this is what it's all about, because going back to Emma's one, that quite clearly used the word legislation, law, and parliamentary sovereignty. So this is the problem we face. It's mass ignorance. What is law? What has the power to bind us? Yeah. How are duties, rights, and obligations created? And that's what we're trying to bring into the consciousness of the courts through the withholding.
Mark, the way I see it is, you know, providing I don't encroach on anybody's rights,
correct,
cause any harm, okay, yeah. It's the umbrella for everything,
yeah,
then I'm free to do whatever I wish.
And that's affirmed in the Justice of Peace Act amongst 1361. So this is something that's been settled 700 years ago. It's not a new problem we're grappling with.
Yeah, there's no there can't be any grey areas.
There are no grey areas,
because like you say, it's been dealt with. And at the end of the day, and I like to say it like this, no one can tell me what to do unless I agree to do it.
Correct. And that's quite simply because until somebody can bring the creator into a court under their own rules, okay, which follows natural justice, to face your accuser, to say that Brian can tell Mark what to do. Nobody can do that. And they need to bring somebody into the court to say that somebody, i.e. 650 Muppets in Westminster, have greater authority than the people.
Yeah.
And we need to be able to cross-examine that evidence to be able to determine the truth.
Yeah.
This is under the court's own rules.
Yeah, absolutely.
And because nobody's managed to do that yet. I'm not saying it's impossible. It's possible. Everything's possible. But until it is actually done, we must follow the best available evidence. And hence fact is our best understanding at a point in time without closing the door to possibility. So there's nothing like settled science or fact. At this point in time, this is our best belief, our best understanding.
Yeah.
Of applying logic and reason to the problem.
Right. Oh. Okay. Let me just pause it there. So should we go on to...
Is it still recording or you paused?
No, I've paused.
You paused. Okay, cool. Okay. So I think then if we just go through paragraph by paragraph, let me just find where I've got the response, and I'll share my screen.
Yeah, cool. 2 seconds, Mark.
Yep.
Right, okay. We won't get interrupted now. It says. Okay, you ready?
Yeah, cool. Cool. Okay. So now that we've seen the extent of their responses to our rebuttal of their claim about creation of duties, rights, and obligations. Firstly, I want to just point out the way that to try and narrow the dispute, which need to separate out where there's agreement, where there's disagreement, because it's what we can't settle in private. That's what we need to ask the court to settle. Mm. And so the way to do that is use a point-by-point response. So what I've done here is basically numbered their first paragraph. Okay, so that's their first paragraph as point 1. And so my, the rebuttal to it will be subpoints of point 1. So this way you can narrow the issues. So by way of example, here they've got 2 statements in the second paragraph. Your statements do not set out any structured legal arguments. Okay, and then you appear to be suggesting that consent is required for council tax to be paid by you. So these then, what we're doing is addressing these as subpoints and sub-subpoints. And this way, now, what should happen is that each of the subpoints need to be responded to. And there's 3 ways to respond to it. You can either admit a point, i.e. there's no dispute about that statement, or you can deny that with counter argument, i.e. put your side of the story or your version of that subpoint, or you can ask for further evidence. And this is the way that you narrow down the issues, because you don't want to be wasting the court's time to deal with irrelevant stuff. Some of it may not be relevant to the case, but you're narrowing the issues that you want the court to resolve, which cannot be resolved in private. Yeah. So this is part of the private dispute resolution, and she talks about that at the end. So we'll do it again. So generally the first one, okay, thank you for your correspondence, blah, blah, blah. So everything's about honor, good faith, clean hands. And that means we need to be respectful to one another. Mm-hmm. So she's gone to the effort of possibly reading something, but at least she's gone to the effort to reply and respond to our dispute. And accordingly, we need to thank her equally for her time for doing that. Mm. And what we're saying here is we will respond point by point. Okay. Yeah. And numbering refers to their paragraphs, so it's clear to them what we do. Yep. Okay. So that's in effect the introductions, the hi, nice to see you again. Let's go and have fun or whatever. So the second point that she makes is that ours do not set out any structured legal arguments, and we appear to be suggesting that consent is required for me to pay council tax. So firstly, the statements set out the legal arguments that until somebody can bring the creator into a court to give cross-examinable testimony, that one person has more authority than another. Now, here's the thing, under the court's own rules, which follows natural justice, that the accused has the right to face the accuser to answer any complaint. Okay, so we're saying this is totally in accordance with the rules of the game. Okay, and until somebody can do that, okay, then we must apply logic and reason. So this is where we derive from the logic and reason that everybody's equal under the law and nobody is above the law, and hence that is actually a fundamental principle underlying the law. So that's our first subpoint, and I can't see how she can rebut that.
Well, it can't be, that can't be rebutted, can it? Because that's the foundation of
law,
of the rule of law.
Correct. Yeah.
It doesn't get any clearer.
Yeah, and so so then further they set out that this is admitted in legislation and common law precedents. Okay, now this here totally rebuts what she's saying. We don't set out any structured legal arguments. We are using legislation and common law judgments in what we're saying. Okay. Now, with legislation, okay, there's something called judicial notice. Judicial notice, legislation is judicially noticed, and therefore people must take notice of it. Yeah. Okay. And it cannot be denied that it exists. Yeah. So acts of parliament exist. They are printed on legislation.gov.uk. Okay, like we saw when you read out the letter first, the Bill of Rights is one piece, and in our arguments, this is foundational to our arguments. So she herself referred to it in that, and therefore this is what is called common ground. We both agree that this document stands. Yeah. Okay. So what it says is the source authority of those still governing today, okay, are successors. Okay, following the claim of the throne being vacant at the time and hence abandoned property under the common law, giving the lawful right to make their claim. Now, that claim, okay, is still to date unchallenged. Nobody's disputed it. Therefore, those who stand on their rights or their beliefs, they proceed. If nobody objects, you proceed, i.e., we're all free to do what we want following our conscience. When somebody says, hang on, question your conscience, then natural law says those who stand on their rights harm no one. And hence we have the saying, those who don't stand on their rights have none, and those who stand on their rights harm no one. So now the Bill of Rights, okay, what again, just to give people a bit more when they start to read legal papers, it's referenced, and here at the bottom is the reference, the link to the source document, and then you'll tend to just make an abbreviation so you don't have to write every time the full word. Yeah. So BOR 1688 is the bill, refers to the Bill of Rights 1688. Yeah. Okay, now this expresses governance is by contract. Okay, so anything they've got to say that consent is required, the Bill of Rights itself affirms consent is required because it itself is a contract. Exactly. Okay. So, you know, that's just one admission that it's nonsense what they're talking. Yeah. So what happens is the Archbishop is making a claim, which, guess what? To date is unchallenged. Nobody's disputed this claim. Right. Okay. And his claim is to have authority from the Creator to offer governance to the people, of the people to the monarchs. That's his claim. Nobody's challenged it. Right. At the time, that was William and Mary, who accepted, okay? And the successors, acceptance, this offer of contract and acceptance is expressed in the Coronation Oath Act 1688, okay?
Mm-hmm.
Now, and in the Act of Settlement, okay, again, she referred to that, therefore it's common ground. Both affirm governance is restricted to the people's laws and customs, okay? So both two of the documents that she refers to affirm our position. She agrees with us. She just doesn't see it.
Yeah.
Okay. Because she's not looking at it objectively, rationally, with an open mind. She's got a preconceived social conditioned belief system.
Yeah.
Okay. So, and that there's expressed here, where you incorrectly assume Parliament assembled can create duties, rights, and obligation on whoever they so choose. That's what she is claiming. Yeah. Parliament can do what it likes.
What it likes, yeah.
So within two of the documents, which we both agree on, have legal standing, that is Parliament sovereignty is utter nonsense. And we'll look at this further. Mm-hmm. Further, it's expressed in the Bill of Rights that Parliament cannot do anything to the prejudice of the people, okay? If we're all equal under the law, nobody is above the law. It's obvious nobody can impose their will upon anybody else. And within the Bill of Rights, it's expressed as the ancient rights and liberties of the people. That there is the individual right to follow your conscience, which dictates right from wrong. And wrong is a harm.
Yeah.
Further, in the legislation, judicially noticed, she must accept this. The rules of equity prevail over the common law in event of conflict. Okay. And then that was established in the Earl of Oxford case in 1615. Okay. And this is an obligation. It's a contractual obligation, okay, which must be upheld by those governing. This is beyond their authority. That this is a duty and obligation they hold.
Yes.
Okay. So, so basically here you can see how legislation codifies the common law.
Yeah.
Okay. So Section 49 of the Senior Courts Act 1981 is the codification of the common law created in the Earl of Oxford case in 1615.
Yeah.
So it's the other way around. Legislation can be codification of the law which is created in the courts. But not all legislation is lawful. Yeah. Only once it's been through the courts can it be determined to be lawful. Yeah. So now what's interesting in here is the admission of the law of the God, and this is from the judgment, okay? The law of God speaks for the plaintiff. Why does the law of God speak? Because in the Coronation Oath Act, the oaths are taken upon the Bible. That act itself is an admission of a higher law than Parliament assembled.
Yes.
Therefore, Parliament assembled cannot be the highest creator of law.
No.
Okay, and it continues that equity and good conscience speak wholly for him, i.e. the rules of equity. It goes on to say that there's no existing law that speaks against him. So there's no precedence in saying in dissent. Everything is in their favor. And the function of equity is to join hand in hand, moderating and restraining all extremities and hardships. So by way of extremity, if Parliament thinks that it's the ultimate lawmaker and can do what it wants, which is what Emma is claiming here, if they decided April Fool's Day next year, everybody must jump off the cliffs of Dover, that is an example of an extremity. But would you do it? No, you wouldn't, because a hardship, you'll kill yourself.
Yeah.
So therefore, equity comes in to correct or moderate extremities and hardships.
Yeah.
And this is why what it says is the rule of equity is it follows the law. So if somebody creates any law in the court, once a law is created in the court, and that can start with a piece of legislation being a claim, that claim goes to court. Under the rules of equity, you argue what is fair and just. If somebody does not argue fair and just, you will end up with an unfair piece of law created in the courts. And then the next person can argue under the rules of equity, apply better knowledge to remove any extremities or hardships.
Yes.
But basically, main points being law of God, i.e. the admission there is somebody through the Coronation Oath Act. There's a higher law than Parliament Assembly.
Yeah.
Law of God includes equity and good conscience. Equity is all about good conscience. Anything that goes against the conscience or is unequitable is unlawful, as simple as that.
Yeah.
And this is a legal obligation under the Senior Courts Act 1981 for all the senior courts to implement the rules of equity, i.e. every single case should be dealt with fairly and justly. And that dispels the myth that from the late 1800s that we are not courts of conscience or of morals. Totally utter nonsense.
Yeah.
So the next rebuttal we'll be putting into her claim is that the Bill of Rights itself expresses Parliament is only the sovereign creator of law over Her Majesty's government. Parliament is only supreme in giving directions to how they will govern. They do not apply to the people.
No.
Acts of Parliament do not apply to the people. Once they've been through the courts, the common law will apply to the people. Now, the Justice of Peace Act, again, we're referring to legislation, this is all in our stuff, affirms everybody is entitled to the peace. Then R versus Hal, okay, that there's the common law affirming, just before, the reason they cannot remove the Justice of Peace Act is because this is beyond the authority of Parliament assembled. It's the common law. The common law is everybody is entitled to the peace.
Yes. Parliament
Cannot overrule the common law because we, the people, create the common law in the courts. So R versus Hal, which is another judgment in the court, affirms that it summarizes the history of the common law in regards to breaches of the peace. And it says that before anyone breaches another person's peace, okay, and in this case, the council is claiming that they have a right to claim, and we are under obligation to pay council tax.
Yeah.
Okay. So before breaching anybody's peace, they must show evidence of harm having been caused to them or their property, or that harm is intended.
Yes.
Okay. So before the council breaches the peace, or before anybody breaches the peace, you must have the evidence at hand. You cannot collect it afterwards.
No.
Then the Commissioner of the Police of the Metropolis of versus Raza in 2009 affirms following orders is not lawful excuse to breach somebody's peace, which makes logic, rational sense, because if we're all equal under the law and nobody's above the law, then we all have the right to go and follow our conscience and be happy and in the pursuit of happiness. And until we've caused harm, or we intend to cause harm, nobody has a right to interfere in our lives.
Absolutely.
And this is affirmed again, that we're all equal under the law and nobody's above the law in the Criminal Law Act 1967 and Section 24A of the Police and Criminal Evidence Act 1984, which says anybody has the right to arrest anybody else who causes harm to people or their property or intends to do so. So according to accordingly, those governing are accountable to the people. There's no way that this can be disputed on the facts, as opposed to parliamentary sovereignty, which is merely opinion. It's a theory.
Yes.
And the reason they're accountable is because they have no legal authority to create duties, rights, or obligations on anybody, unless they can show authority from their principles, in this case, the creator. And if they believe that they are representatives, they must show authority from us. And democracy and voting does not grant that authority, because not everybody votes or agrees with everything. Okay, but so basically those in parliament, we are the principals, the people, and they are our agents.
Yeah.
Okay. If they're claiming to be in the position of representatives. Yes. So basically what we've said here is you saying that we have no structured legal arguments. I've just gone through the summary of the legal arguments, and I've gone through the summary that consent is required. Okay, so I've responded to both of her points
in great detail.
Well, this is not great detail, because the detail gets there's even more evidence than what I've shown so far.
Well, of course, yeah, but I mean, this is good. This is great. This, as far as I'm concerned, this is great detail.
Oh yeah, for most people, this is way. Yeah. This is
stuff. I mean, realistically, she needs to come back and respond to this.
She must, and you'll see now. She gave us this case, Meads versus Meads, which is a fantastic case.
Yeah.
I mean, I've seen in lots of different case law about the different arguments that people use, like straw man, unilateral contract, and all of this.
Yeah.
However, this case, just like R versus Hal, in the breach of the peace, summarizes the history of the law. Meads versus Meads does the same. With what they call organized pseudo-legal commercial argument litigants, or OPCA. Okay.
Yeah.
So basically, what she's done here, by providing us this case law, we accepting it, and therefore this is common ground again. Yeah. There's no dispute about what's in here. So. Now again, what she's done is she's made, there are no legal principles that you're required to consent before being bound by the laws made by Parliament. That's one statement. The next statement then is that she believes that what we're doing is pseudo-legal arguments due to the common thread of arguments by these litigants, all being similar in nature, specifically that in order to be bound by law, you have to explicitly agree to it, akin to entering a commercial contract. So she's made multiple statements in here.
Yeah.
So let's first, what I've done here is pretty in-depth gone through this judgment, because it's an excellent judgment. It puts to bed a huge amount of the, what I call rabbit holes, like, straw man. There's a trust with a pot of gold at the end, with your name on it. Endless rabbit holes. The Justinian deception, the use of words and language and trickery and all of this nonsense. So basically, her first sentence, there's no legal principle that you're required to consent before being bound by the laws made by Parliament. So what we're saying is, you're wrong in fact and in law. Okay. No person can be bound to any obligation created by another unless you have consented to be so bound. Okay.
I mean, realistically, Mark, right? We really should be ending the video there.
Oh yeah, no, but basically that's it. Yeah.
But we have to go through the rest of it, don't we? So
yeah, and basically the rest of it is what gives us standing.
Yes.
Right? it's saying, look, this is not just one sentence.
Yeah.
This is supporting that sentence. Okay.
Absolutely.
Because ultimately, once people understand we're all equal under the law and nobody's above the law, if somebody comes and asks you, or a policeman wants to give you a fine, you simply turn around to them and say, as we are all equal under the law and nobody's above the law, can I do what you're trying to do to me? Can I do that to any other person? Yes or no? If the answer is no, then there's a privilege. And it's an admission that the actions are not lawful because we cannot all do it.
Yeah.
Okay. So again, we're being polite. Thank you for Meads versus Meads. I wasn't aware of this case before, and hence this is now common ground. She's committed herself, and this is the lovely thing. They will always try and find an excuse, and in that excuse, you will find that there's a silver lining which supports your viewpoint and shoots down their viewpoint. And this one, it's clear that she's not even read the judgment.
No.
Absolutely clear, crystal clear. Somebody's told her, oh, there's this judgment, Meads versus Meads about upcode. Just
throw that in.
Just throw that in. Then they'll never read it. Okay. So that actually creates obligations upon them that they must respond to our arguments. Yes. So now she's created upon herself, by referring to Meads versus Meads, the obligation is set out in there that she is obliged to respond give us a full, accurate, and complete response to our arguments. Each argument must be responded to, as I say, in a point-by-point way, so that we can minimize or focus in on what's still in dispute to stop wasting the court's time.
Yeah, absolutely.
Okay, now when I say at 7, the judgment is set out on a point-by-point basis. And so at 7 will refer to the Meads versus Meads judgment, point 7, so that people can go through the judgment themselves and interpret it how they want. So the response to that basically is equitably substance prevails over form. My arguments do not relate to the paper mask of the form of my name. So they're basically, one of the accusations against OPCA is, whether my name's written in big letters, small letters, etc., however I choose to write it with semicolons or whatever. They class that as a paper mask. Now, what is Parliament assembled? It's a paper mask. So therefore, they tick that box. We're not even relying on that. Okay, at 11, they talk about notarized documents and colored ink. A lot of these people think that if you use blue ink, it's, I don't know, the dead, and red ink is the live, or purple ink is whatever it is. We don't rely on anything like that. Now, some people need to understand what are notarized documents. A lot of people argue, and this is also something that the OPCAs will argue, is what's called the four corners rule. To give you an example of the four corners rule, okay, is basically here I've got a load of papers, okay? If I'm referring to all of these papers together, that is what the four corners rule means. Now, when you have something notarized, I've got an example here, I've got it in the flag. Basically, it's bound together. So a bit like this, everything that's contained in here would comply with the four corners rule.
Right.
Okay? So when you notarize documents, instead of just having a load of loose leaves like this, it will get bound together, either with a brass seal or something like that, or with string and a seal. And then the notary will sign that he's witnessed this. Okay, and that is what the four corners rule means. It doesn't mean if I've got a box within a box, okay? Yeah. So on this piece of paper, there's a box within a box. There's a box within the big box, and there's another box, and there's another box. The four corners means on this piece of paper, from this corner, this corner, this corner to this corner, everything that's contained within there, that is the four corners rule. And you don't take out little boxes and
Quite
pieces.
simple.
Very
Yeah.
simple. Okay, now at 16, God's law is superior to any legislation created Parliament who derives their contract from the successive monarchs. So this basically is a reaffirmation of what we said in our introduction up here. Okay, this was a summary at point 2, okay, about consent. However, here we go further, okay, that in the event disputes cannot be settled in private, then through public dispute resolution in the independent courts, their respective laws are created as affirmed in the unanimous 11-judge Supreme Court ruling of, and this is the Boris Johnson judgment, which again I suggest people read. It's an excellent judgment, which affirms that those governing are responsible to a court of justice for the lawfulness of what they do, and of that the court is the only judge. So even Parliament assembled, the lawfulness is determined in the courts.
Just read it one more time, Mark.
Yeah.
Just read that sentence one more time.
So those governing are responsible to a court of justice for the lawfulness of what they do, and of that the court is the only judge. So this affirms that legislation is not law.
Absolutely. 2019.
Yeah, and Boris Johnson himself relied upon the Bill of Rights, which is another document we rely upon. So everything that we look at, whichever angle we look at it, it is coming to the same answer. Law is created by the people in accordance with the monarch's second promise. Okay, the second promise creates an independent judiciary. It is independent from the first promise. The first promise is to govern. So the judiciary is independent, and the lawfulness of their actions, i.e. we the people will sit and argue in the courts when they do something unlawful, and create the law which controls and restricts, and therefore itself again affirms there is no such thing as Parliament is sovereign over the people.
No.
Okay, they cannot create duties, rights, and obligations.
No.
Okay,
and it always comes back to no one can create an obligation for another.
Absolutely.
There is no power. There is no
power.
People say, oh, well, they've got the power. The police have got the power. They haven't got any power.
No, they've got violence.
They've got
threats of violence.
Yeah. Yeah.
Okay. That's not power.
No.
That there is unlawful.
Yes.
We all have the right to self-defense.
Yeah.
Until somebody can bring the creator into the court to say that I can enforce my will upon you, nobody has the right of attack.
No. Absolutely not.
Okay, then at 92, it talks about, you get these people saying, oh, I'm a living man, a natural person, a living woman, blah, blah, blah. Again, equity prevails, and we're not using any of these arguments.
No.
In fact, they are using this argument by saying Parliament assembled is supreme.
Yeah.
So again, they're ticking the boxes and we're not.
Yeah.
At 101.1, okay, it talks about oaths, because people will ask judges, police, etc., are you acting under your oath, affirmation, or attestation? Now, in one of the responses that we've had, they've actually said that the oaths and the coronation ceremony is ceremonial, utter bull. An oath is what binds you, okay? It is what you agree to. It binds you to the duties, rights, and obligations contained within the oath. So the Queen's Oath says, I promise to govern the people of lists all the countries that they control according to their respective laws and customs. That's the contract to govern. No member of parliament voted in can do anything unless they make their oath, affirmation, or attestation. So that there is the social contract. The oath, affirmation, and attestation is the contract to govern. And those oaths restrict what can be done. So just quickly going back to the Bill of Rights and the coronation oath, which is the source, the fountain of power, okay, is to govern the people according to their respective laws and customs. That is why in the Bill of Rights it says nothing can be done to the prejudice of the people, because they cannot impose duties, rights, and obligations without consent.
Yeah.
So again, whichever way you look at it, okay?
Doesn't matter.
Yeah. So then at point 2 of 101, the Bill of Rights, again, which is common ground, is a contract. The coronation oath creates duties, rights, and obligations between the contracting parties. Therefore, governance can only be by contract. Okay? I.e., consent. The next one's dealt with at 4.2.3 above. Then the next one's about people relying on Magna Carta. So I'm pointing out Magna Carta 1297 is still statute law and stands. It has supremacy, being first in time, first in line, in addition to following natural law. And we'll talk about that because that's another argument that comes to. We don't use A for B. We're not using any religious immunity. We're not having any arguments about money or the way money is. We're not having any arguments about corporate personalities. But all of these are actually arguments they're using. Instead of religious immunity, equitably, you change that to parliamentary immunity. A for V, they're chasing us for money. So 1 and 3 is about money. And the corporate personality is what they're using by calling themselves Parliament Assembled.
Yeah.
Okay, then these two sections, again, just reaffirm we're all equal under the law. Nobody's above the law. Then, okay, at 135, I can't remember off the top of my head what that claim is, but under the court's own rules, until the claimant can bring the creator in. Okay, so this, I guess, is what they refer to something about God's law or being above the court's authority. We don't use any arguments regarding legal fictions.
No.
And I'm repeating this thing about bringing the creator into the court because it's mentioned in so many places, okay, that it needs to be equally mentioned to reprogram, basically. Okay, all human interactions can only be by contract. What is a contract? A meeting of the minds and free will and consent. That means there can be no mental coercion, and that there is, for instance, covered in the Fraud Act, amongst many other acts of Parliament.
Yeah.
And no physical coercion, which is basically crimes against people and against their property. So that's what free will means. No mental or physical coercion, a meeting of the minds. And then consenting to the respective duties, rights, and obligations. Okay, now this is where it starts to get interesting, okay, because this is the thing about unilateral contracts or unilateral agreements. What they're saying is that what we're saying is because there's no consent, if you don't comply with what I'm demanding, then you've acquiesced, and therefore this is a contract by acquiescence and stuff like that. Now, that there is their claim, and they are guilty as charged. Using different names, because equity is about substance and not form, okay? They're using the word act of Parliament is law. That and that's how duties, rights, and obligations are created, and therefore, through bringing up unilateral contracts in Meads versus Meads under the color of law, that's exactly what they're doing. So they are guilty of what they're charging us for doing. Okay, and that there will be, we'll look at that because that's a pretty well covered section in Meads versus Meads. Okay, the language, legal grammar, all of that stuff, we're not arguing any of that. We're not arguing anything under the UCC. We're not arguing under freeman of the land, I can do what I want. But we actually are arguing exactly the opposite to that. I can do what I want. Okay, we are saying people need to be held to account for harm they caused.
Yes.
Okay, so we don't argue the right to bear arms. We don't include a unilateral contract fee schedule. Okay, what we do is a trespass on the person. That there is a legitimate cause of action. We're not arguing about admiralty law. We're not arguing about cannabis. We're not arguing about making a religious claim. We don't argue about motives of the names. We don't argue document formalities or how they're, which color ink they're in. If you've got your thumbprint on.
Yeah.
We're not arguing phrases and language. We are arguing, we're not arguing that legislation and legal documents have no authority over us. That is exactly the opposite of what we're doing. Okay, we're doing exactly the opposite of what that claim is. We're not arguing anything about atypical mailing addresses, whatever format you want to do it. So for her to make reference to our arguments as OPCA are not supported by her own case law trying to prove the opposite. Okay, so it's utter irrationality. But this is what people need to understand. They do not understand or even apply their mind to what they write.
No.
They quite simply have a job. They've been taught how to do the job. Nobody's ever bothered to read the rules. And they just do what they're told.
Yeah.
Okay.
Yeah.
And this is what I call, we have a situation of mass ignorance. We don't know our rights, duties, and obligations. Here, Emma clearly doesn't know her rights, duties, and obligations. The police don't know their rights, duties, and obligations. Parliament assembled doesn't know its rights, duties, obligations. Even the courts don't know their rights, duties, and obligations. It's mass ignorance.
Yeah,
that's the problem we face.
Yeah.
It's not corruption or anything like that. I see loads of evidence for ignorance. I don't see much evidence of corruption.
No.
So at 262, it's not only justice, must justice be done, but it must be seen to be done. I can't remember what that point is. This is contempt of court, because they actually discuss in that discussion, how can we deal with these OPCA litigants? Oh, well, we can get them on contempt of court. And this particular one is that in regards of people making clandestine recordings, I think is the wordings. Magistrates courts and county courts are not courts of record.
Yeah.
So what is a contempt of court? A contempt of court is quite simply anything where a party is prejudiced. Now, in a criminal matter, or in this case, who's the one that can be prejudiced? Who's the one that can be harmed? Me. If you want council tax from me, I'm the one that can be harmed. So if I record, I cannot be held in contempt of court.
No.
Because it's not going to, what's the worst outcome? If I'm happy with it to be recorded, I'm accepting, worst case, I'm going to have to pay anyway.
Yeah.
So it's up to me to decide whether I want to create a record.
Yeah.
Because there is not a free public record. So every single case I should be able to record.
Yeah.
Because if I'm the defendant or the respondent, I'm the only person that can be prejudiced by that recording.
Yeah.
If I'm happy to be prejudiced by it, then tough, I will do it. And the court cannot hold me in contempt of that. That there is an abuse of power.
Yeah.
Okay. So then basically it goes through, I've summarized, I've followed the format of the judgment basically. So pretty much everything we've talked about so far is summarized again. That we don't argue admiralty or military courts, coat of arms, flags, gold fringed or not. We don't argue about notaries being judges or real judges. We don't include religious or belief trumps the court. We argue basically the rules of equity are an obligation of every court. Best expression of natural law, God's law, universal law, by any color of law, whatever you want to call it. So they've lumped another set of arguments then as exempt groups. So these arguments include Aboriginal status, which, guess what, is expressed in the Bill of Rights as ancient rights and liberties. So to say that you can't be exempt because you're relying on your ancient rights and liberties is utter nonsense. It's absolute irrationality. It is that which creates the rule of law. So then now it starts to get interesting, because with these exempt groups, parts of it claim that the common law is subordinate to legislation. This is in their judgment. So on one hand, they're saying that Parliament is supreme in part of this judgment. Okay, it's factually incorrect in the heart of the problem, like we've said. Now, when arguing about parliamentary sovereignty, it's actually irrational, okay? Because guess what? They are claiming to be an exempt group above the rest, just like they're saying an OPCA person is arguing that they exempt from the rest.
Yeah.
Neither can be true, because we're all equal under the law and nobody's above the law. You know, now, in regards of the parliamentary sovereignty, okay, it is absolutely irrational, the argument that Parliament can be sovereign, from what I've said so far. But if we look at the separation of the powers, which is one alleged foundation of the democratic system that we live under, okay, and that is, if Parliament is sovereign, ultimate creator of law, and everybody must comply, what on earth is the point of having the courts?
Exactly.
And so again, you can see the irrationality of their thinking. Again, now here it becomes interesting, because one of these arguments is that the courts don't have jurisdiction. Okay. Now, what I've just sort of argued there, within this here, it actually states that the courts of Canada are a separate, distinct, and independent branch of government. So they've just directly contradicted a few paragraphs before, okay, because this is at paragraph 352, and there's loads of these references that the courts are independent. So in literally from one paragraph, exempt groups, the next section, okay, they are directly contradicting their own belief. Okay. You know, it makes an absolute mockery out of their logic and reason.
It really
you
does.
can't have both. You know. Okay. The next thing is that they talk about is obligation requires agreement is an OPCA argument. Okay. So parliamentary sovereignty or supremacy is founded on unilateral creation of duties, rights, and obligations, destroys the foundation of the rule of law, which is all equal are under the law and nobody's above the law. So again, they are arguing that the OPCA people are arguing obligation requires agreement, and they irrationally are using that same argument to suit themselves, that obligation doesn't require agreement. So how can you say that legislation doesn't require agreement? However, if an OPCA person says, they're bound by agreement, you've got, again, this logical fallacy. You can't make this nonsense up. It's ridiculous.
Unreal, isn't it?
Yeah.
It is unreal.
Okay. So basically what's happening in equity here, okay, is the state is claiming to have the right to engage in unilateral action. And it immediately contradicts itself by saying that there are no restrictions on government. If they can just unilaterally do what they want, and on the other hand, they argue the opposite. This is how irrational it is. And really, the point I'm trying to drive home here is, in one judgment, you can see the irrationality. Okay, there's no logic and reason. It argues one point, it argues another point, but the 2 points are mutually exclusive. Okay, so if in one judgment where a judge has applied their mind, how on earth can you reach these statements? Okay, and this is what I'm talking about, the level of ignorance and the lack of applying your mind. Okay, group C is the argument of double or split personalities. This is the nonsense of people, here's my birth certificate and all of that nonsense. Unilateral agreements, we've already talked at some length. That we've talked about, meeting of the minds, consent, okay. It goes on basically to say about unilateral agreements that they are unlawful, and what they're trying to do is actually get us on vexatious litigation. Okay, that's what they're trying to move us into, right? However, vexatiousness is basically what they do. Okay, going back to this nonsense of parliamentary supremacy. Okay, they talk at length of these money for nothing schemes, which is actually quite interesting, which includes the fictitious sestake V trust, offsetting birth certificates, and then they've got a miscellaneous money for nothing scheme. Now this is actually quite interesting. Okay, so they've talked about A for V, promissory notes, all the stuff that people try and do. However, again, let me just take people to this, because this here, again, is an admission by the Bank of England. Okay, and it explains, rather than banks lending out deposits that are placed with them, the act of lending creates a deposit, the reverse of what is typically described in textbooks. This is from the Bank of England's website.
Yep, it is. Yeah.
So it continues to say, which are essentially IOUs from commercial banks to households and companies, and currency, mostly IOUs from central bank, from the central bank. And in the modern economy, those bank deposits are mostly created by commercial banks themselves. Commercial banks create money in the form of bank deposits by making new loans. When a bank makes a loan, for example, someone taking out a mortgage to buy a house, it does not typically do so by giving them £1,000 worth of banknotes. Instead, it credits their bank account with a bank deposit the size of the mortgage. At that moment, new money is created. It tells you this. This is them telling you.
Yeah. It's not.
We make money out of nothing.
Yeah, absolutely. Yeah, it's not hidden.
Okay? So it's not hidden.
No.
And so for them to again accuse people of using money for nothing scheme, that's exactly what they do. This scheme does.
Yeah.
Again, totally irrational. Nobody bothers to read or apply their minds. So basically, it goes on then in summary to summarize sort of these things. But basically, again, there's numerous places which totally contradict parliamentary sovereignty. You know. So had she bothered to read Mead versus Mead and comprehend it, she would understand that parliamentary sovereignty does not exist in legislation, the fact of what is written in acts of parliament, as well as in law. Let's see what else is in here. Okay, Lord Diplock, he has made a great summary of what is the rule of law in the Attorney General versus Times in 1974. Basically, all have unhindered access to courts for determination of disputes and liabilities. They must be free from any bias, i.e., for instance, legislation is law, or this nonsense of parliamentary sovereignty. The decision will only be based upon the facts proved in evidence, and there shall be no usurpation other than to decide by law. So it's very clear what the due process of law is. And this judgment continues, anything calculated to prejudice any of these requirements or to undermine public confidence, they will be observed as a contempt of the court. The court is a fiction, okay? So if people act in contempt of their obligations to the court, that is contempt. Okay. So basically, in summary, your arguments are for the creation of an obligation is merely based upon a theory of parliamentary sovereignty that totally undermines and contradicts the separation of powers, and it ignores the Supreme Court. Okay. We argue using both legislation and case law, and accordingly fail to see how you can claim our actions are opca. Out of the listed items and decisions, you argue your argument of parliamentary supremacy and legislation is law meet more than the more of the opca criteria, and I find it stunning you would choose to rely on this judgment. Further, your obligation as an officer of the court to the rule of law, you must, as 6.32 and 6.3, evaluate each argument and respond in a meaningful way, as detailed in closing to my response. So we're telling them, wonderful, thank you for this judgment, it's great. And you have brought it and we've accepted it, therefore it's common ground, and now you have to fulfill your obligations under that judgment.
Absolutely, yes.
Okay, I think if we just have a quick break there, Brian, let me just go and get Carrie out.
Yeah.
Because she's been getting a bit. Okay, so her fifth paragraph then, she states the principle underpinning our constitution. Okay, now first, if we look at the word constitution, okay, that is the source of authority, what is being constituted. Okay, so what she's saying, her first claim, okay, is that Parliament is sovereign. Okay, the next statement that she makes is which can make or unmake any law it wishes. So here she's relying on the Bill of Rights, and so the Bill of Rights is one of them, and the Act of Settlement. Okay, I'm not bothered about that. It affirms, basically in regards to Scotland and all the other countries, they are subject to UK Parliament. The devolved powers is basically a principal agency relationship where they delegate certain powers to anybody to do. No different from primary legislation delegated, created by Parliament assembled, which delegates authority to the ministers to create secondary legislation.
Right.
Okay. And the third claim, and the point here is we have common ground. We rely on the Bill of Rights, and we rely on the Act of Settlement. It's actually 1700, not 1701, but that's a form. I'm not bothered about that.
Yeah.
Okay, if any law of Parliament could be defeated by just saying, I do not consent, this would defeat any laws passed by Parliament, which is absolutely correct.
Yes, that's the whole point.
That's the whole point. Okay? Parliament cannot act unlawfully. They are bound by the law. Nobody is above the law. We're all equal under the law.
Yeah.
So again, to rebut her claim, okay, so the first one, the principle underpinning our constitution is that Parliament is sovereign, okay, and the Bill of Rights rebuts that immediately. It creates the authority of those governing today, which is common ground. We're not disputing it. She's said it, we're saying it, okay? It itself is a contract with terms and conditions. And it's those terms and conditions which constrain the limits of the authority of those governing. Okay, so the document itself, she hasn't read the Bill of Rights either.
No.
Doesn't comprehend it. Okay, it puts constraints and limits upon what they can do.
Absolutely.
And when the Crown's accepted in the Bill of Rights, okay, it affirms nothing can be done to the prejudice of the people's ancient rights and liberties. And also, guess what? There's no authority for taxation.
There's a surprise.
Okay, the only authority is that Parliament assembled must approve any levying of money for or to the use of the Crown. Okay, so it's not to go and run the country. They don't have authority from the Bill of Rights to go and run the country and make a health service or do, all of this nonsense that they're doing. So again, in the Bill of Rights, which is common ground, it actually affirms Parliament is only sovereign over Her Majesty's government. Okay.
Yep.
And it's claiming to have lawfully, fully, and freely represent the estates of the people of the realm. So they're claiming the people have given us authority to create this document, but this document says we can only, as Parliament assembled, we can only tell the government what to do.
Yeah.
They can't tell the people what to do.
No.
Okay. So really it comes down to a question of law. Why on earth, Parliament's been around since 1200 or something like that. Why is there no definition of law?
Yeah.
But more importantly, okay, by impossibility, it cannot include new acts of Parliament after 1688. Why? Because they weren't existent at the time. So again, it's utter irrationality. They've claimed this authority to govern according to the people's respective laws and customs at the time in 1688. So they've agreed already to govern according to the laws and customs. So how can you think that you can change the laws? Because you've already agreed you will govern according to the laws, which is irrational and an impossibility from time.
Yeah.
So Parliament cannot be sovereign because it promises to govern according to the laws, and therefore it's an impossibility. It can create new laws. It's self-constrained. And this question of representatives, because remember, the claim was to represent the people and their states. So what does represent mean, or representative? So represent is specifically in legal action to speak and act with authority on behalf of another by deputed right. So this is the etymology of the word. That there is a principal agency relationship.
Yeah.
Okay? Therefore, I must give authority for you to act on behalf of my behalf.
Yep.
Okay. And so basically described as having a specified character or quality, we need to say what it is. And in the legislative sense, and this is attested from around 1650, so this is round about the time of the Bill of Rights, be accredited deputy for a body of people in a legislative assembly, i.e., again, principal agency. We tell them what to do, they don't tell us what to do.
Exactly.
Okay. So in practicality, yes, it would be difficult on an individual basis if you're looking at their model of governance, which is a top-down model, where you have representatives, okay? But they don't have authority to do what they're doing. That's not our problem. They need to govern according to what they undertook, the duties, rights, and obligations to govern us according to our laws. They need to put in place a system which delivers their obligation. So democracy does not meet that requirement. Both in legislation and in law, nobody has the right to cause another harm. So that automatically constrains each individual representative in Parliament assembled not to be able to cause another harm. That's expressed in the Bill of Rights, that Parliament cannot do anything to the prejudice of the people.
Yeah, simple as.
Okay. Now, judicial notice must also be taken. She didn't refer to the Coronation Oath Act, but in some of the other responses we've had. Okay. So that affirms statute agreed upon in Parliament assembled differs from law, which both differ from customs. So to say that Parliament assembled is the supreme lawmaker is irrational and is actually the opposite of what it's actually expressed in its own rules. And you know, and again, that's affirmed in the independent judiciary. That's where we create the laws, in the courts. Parliament cannot create laws upon us. It cannot create duties, rights, and obligations and impose them on us. So the other common ground which you need to take judicial notice of is the Act of Settlement 1700, which says quite clearly, the laws of England are the birthright of the people thereof, i.e., the laws come before Parliament.
Yes.
All kings and queens who shall ascend to the throne of this realm or to administer the government, i.e., how they govern,
yeah,
okay, of the people, according to the said laws, i.e., our laws which are our birthright,
yeah,
and all their officers and ministers ought to serve them respectively according to the same. It's we create the laws. They do not tell us what to do.
No, no.
So basically what we're saying here is you put to strict proof that Parliament assembled is supreme creator of the law and stands above the independent judiciary. The concept of Parliament sovereignty and supremacy is irrational, and as there must be constraints upon it. Otherwise, it would simply be a dictatorship by another name.
It's real simple to see that, isn't it?
Yeah.
Unbelievable.
Okay, but you see, whichever way, again, I really want to drive home this point. It's an issue of ignorance. And that's because people don't choose not to apply their mind. Okay. And it's clear that Emma's not applied her mind. Just like in the Opka judgment, it's clear that the judge that made that judgment did not apply his mind.
No.
In the separate parts, he might be correct, but in his conclusion, he's incorrect. Okay. Yeah. So based upon the evidence, you can't reach that through the application of logic and reason, you can't reach that conclusion. Okay, so her sixth paragraph is whether you are a free body, God-made, or any other superlatives that you use, that your consent any other superlatives that you use, your consent is not required to be subject to acts of parliament as set out above. So what she's saying is, based on what you said so far, you know, I've shown you, I've hence rebutted your beliefs that you are not subject to acts of parliament because you've not consented. Whereas in fact, we've shown using all the evidence of which we both agree, and I mean Emma and us, the people, consent is required. So again, it simply goes back to bringing the creator into the court of the law. Until then, we can only apply logic and reason that we're all equal under the law and nobody's above the law, and therefore I'm putting you to strict proof to prove your claim.
Yeah.
Right. So now she goes on to, again, with this aloof attitude, we don't recognize the notices that you provide. Okay? These have no legal basis, and indeed, the website says go and seek your own legal advice. She's correct, because it depends on what does the word legal mean. Okay. So in response, whether you choose or not to choose to recognize the notices is entirely up to you. You've admitted you've received them, and affirmation of having been put with the knowledge contained therein. You are now with the knowledge, and you've confirmed you with the knowledge.
Yeah.
Okay. And affirms, should your actions be unlawful, then you have acted grossly negligent. And if that includes people thrown out of their shelter, that would be reckless, i.e. Okay, so what is a notice? A notice, quite simply, is putting somebody with knowledge or information.
Yeah.
There's equity prevails, substance over form. I'll put my message across in whatever form I believe serves the purpose. And what you choose to do with it and how you choose to apply your mind, not my problem. No. I've put you with the knowledge.
Yeah, you've got it now. Yeah.
So you've got the knowledge. Not only have you got it, you've admitted you've got it.
Yeah.
And by responding, it would appear with your response that you've read it. Okay. You might not have comprehended it or applied logic and reason, but you've admitted you are with this knowledge, and therefore you now are liable for any unlawful actions which result of being with this knowledge.
Absolutely.
So, you know, and like I say, I mean, at the end of the day, you know, yes, there's no legal form. I'm not bothered about legal, I'm bothered about lawful.
Yeah, absolutely.
Okay, so point 8, the accusation is you appear to have misunderstood the term common law. And then she goes on to admit common law is the development of law by the higher courts. That's true. It fills the gap between legislation made by Parliament. That's also true. Parliament is sovereign. That's not true. And by that she's claiming takes precedence over previous court decisions. So that's where the problem comes in. And courts are required to interpret existing common law principles consistently with legislation. That's true as well. So it actually appears she's misunderstood the term, as it controls the unlawfulness of everybody's individual actions, including that of Parliament assembled. So, and the ministers. So with what she said there, it's clear she doesn't understand what common law is and the authority. But again, purely coming from the view that the belief is legislation is law and is parliamentary sovereignty. Utter nonsense. So even for basic common sense, this is irrational to think that Parliament is sovereign, because that would mean it can do whatever it wants without any constraints. Yeah. There must be constraints upon what it can do.
Yeah.
To believe otherwise is totally irrational.
Yeah.
Okay. So now the next one is basically your statements in relation to the pre-action protocol appears to confuse the law relating to contracts and alleged rights under common law with legislation relating to council tax. Okay, a pre-action protocol is any method to resolve any method and actions taken to resolve dispute in private before public dispute resolution. We need to explore all alternatives before we go and waste the court's time. Okay, and that there is what a pre-action protocol is all about. Again, she goes quite simply back to the only argument that she's got: legislation is law, and therefore under Local Government Finance Act you must pay. And subsequent regulations being secondary legislations with conferred powers from the Local Government Finance Act. She goes on again to reiterate it's not contingent about your consent or a contractual relationship with the council. And then she says that we're wrong, council, our interpretation is incorrect, that consent is required. So again, so this one specifically, basically, she misunderstands what a pre-action protocol is. Now, like I've said, this is developed under the rules of equity to attempt in honor, good faith, with clean hands to resolve any dispute in private before bringing it to public dispute resolution, so as to avoid wasting public resources on in the provision of the independent judiciary. I fully understand your belief where you think that I've got to pay. What I dispute is under section 34(6), okay? You are under obligation to satisfy the court that the sum has become payable by myself. Hence, that requires proof of how I agreed to this obligation, as no one has authority to create an obligation on myself other than myself. Okay? And I've argued this and with both legislation as well as case law. Accordingly, you are put to strict proof to prove my obligation to pay your demand.
Still asking the same question.
Exactly.
Still not getting the answer.
Yeah. Yeah. Okay, and then it goes on, just because you happen to live on there, you know, that's why you got to pay. I've already addressed this in point 9 above. The council will proceed against you for non-payment of council tax if it remains unpaid. You will have the opportunity to place these arguments before the court should you wish. I would, however, strongly seek you to get legal advice. So basically, should you proceed as you threaten to, okay, she's making a threat now, and fail in your obligation to respond to my points in a meaningful way, this will be brought to the attention of the court. Further, should you choose to do as you suggest, ensure that you fully inform the courts of this dispute when you lay your complaint. At the same time, please ensure you provide details of your case progression officer under the Magistrates Court's rules. So I think this 12 is a last paragraph, yeah. So the council is clearly set out, so basically what she's saying, I've done this twice and I'm not going to correspond with you again. Okay, so basically in regards to this paragraph, I remind you of your legal obligations under my common law rights expressed in this judgment. And that says, now she's a legal professional and she must act within certain ways, which are obligations under her contract.
Yep.
But basically, the common law right is misleading the court is and must be regarded by any disciplinary tribunal as one of the most serious offences that an advocate or litigator can commit. I.e., if you don't do your job properly, Emma, this is a serious matter. It'll normally attract exemplary and deterrent sentences because the standing of the profession particularly depends upon the discharge of the duties owed to the court. Now, what most people don't realize is that solicitors, barristers, Queen's counsels, judges, everybody, they are officers of the court.
Yes.
Their obligation is to the court, okay? And the court is about upholding the rule of law.
Yeah.
So basically, this year is even legislatively, i.e. in Acts of Parliament, Parliament recognizes this obligation, okay, in the Legal Services Act 2007, which basically says they must follow their professional principles. It's an obligation.
Yes.
It's not a matter of choice.
No.
So what are their professional principles? They have an overriding duty and obligation to uphold the rule of law and the constitutional principle of the rule of law. Their duty to the court overrides their duty to their clients. And each one of them, okay, not individually, the prosecution presents one side of the story and the defense the other side of the story, but each officer of the court must provide the court with relevant law, including dissenting opinions which may undermine their case.
Yep.
Okay, now we sold already, I've said to you about equity. Every court case must be dealt with equitably. What the reason for that is we don't want to be reinventing the wheel time after time again and wasting public resources by having to have a massive independent judiciary. Okay. So, and that affirms that courts are moral, i.e. it's about conscience. Every court and every judgment must be done to reach a final equitable or as final equitable settlement as possible. The other myth or marketing ploy of the legal profession is that we live in an adversarial system, i.e. defense fights against prosecution. That is nonsense. The days of sword fights and pistol duels is long gone. We've learned through history that it's about the rule of law. And that means, and we've put in place officers to uphold the rule of law, including the police. Everybody's oath ends or includes according to law. The law stands above everything. Why? It's the foundational principle of living in a society in peace.
Yeah. So
basically, this particular obligation in the professional principles of the legal profession, okay, specifically says we are not an adversarial system. The officers of the court operate to get a fair and just settlement.
Yes.
Okay, and they work together to get a fair and just settlement. It's not one versus the other. So both marketing myths of the legal profession are absolutely in breach of their own standards.
Yeah.
Okay, now they've got a special obligation because it's to the rule of law not to attempt to deceive or knowingly or recklessly mislead the court. Now that Emma's with this knowledge when she gets this reply, should she not inform the court of our dispute, she would be attempting to deceive. She would be knowingly attempting to deceive and recklessly mislead the court. She must act upon this.
Yep.
Okay. Now, this next one, it dispels the myth of a lot of excuses that these rabbit hole people use with Justinian deception, the use of legalese, commas, and different languages spoken in the court, and admiralty law, and all of this nonsense. It's an obligation of the officers of the court to take special care when dealing with litigants in person to use plain language.
Yes.
Okay. Hence, when they ask you, do you understand? They are asking you in plain language, do you understand what I'm saying?
Yes.
Okay? It's nothing, it doesn't
mean anything else.
Obligation or anything else.
Yeah.
Okay. And not to take advantage by bullying, unjustifiable threats, misleading or deceitful behavior.
Yeah.
i.e. act with honor.
Yeah.
And clean hands. Everywhere you look, it comes back to equity.
Yeah.
Equity says you cannot claim what you cannot rightfully claim, and you cannot create a dispute where none exists.
Yeah.
Why? Because both of those are a breach of the peace.
Yes.
Okay. So, Emma, please respond accordingly, in accordance with your obligations.
Yeah.
And notify the court if you want to proceed.
Yeah, we look forward to your response, Emma. Let's do the fair and just thing.
Well, honor
and settle the
settle the dispute.
Settle the dispute amicably.
Yeah,
in the right way.
And then basically, the last one then really is the Cheney versus Connell, whatever it was, 1968 judgment.
Yeah.
That one's easily rebutted by the unanimous Boris Johnson judgment in 2019.
Right.
That affirms that the lawfulness of their actions are determined by the courts, and the courts are the only judge of it.
Yeah.
And those are all the arguments that they've been able to come up in rebuttal, or attempts to rebut what we've claimed.
Yeah.
So hopefully people have got a clear understanding of what's going on now. And black belt barrister, anytime. Come on, let's have a debate about this.
I think it would be nice. It would actually be nice to have a real, conversation with these people. We're not conspiracy theorists.
This is using their legislation, Brian, the common law, everything.
Yeah. There's no conspiracy theories involved in this. It's just legislation, common law.
Yeah.
I mean, we can't make it any clearer, really.
Yeah.
So
why? Because we're all human, aren't we, Kerry?
Right. Well, that's okay. That's fantastic, Mark. What we'll do is obviously we'll get this up on YouTube, and hopefully a few people will watch it. And we'll leave the links in the description for the download, so you can have.
Yeah, we'll put up the downloads. I'll just add the summary, which will go at the beginning, and then literally I'll add in Cheney versus Con, the rebuttal.
Yeah.
And then basically anybody can just copy and paste whatever, because the councils are starting to use templates now as well.
Yeah.
They're obviously talking to one another.
Yeah.
They realize they've got a problem. It's time this problem's addressed and we get to the root cause.
Yeah, we need it resolved.
We need it resolved.
All we're trying to do is resolve it in the right way.
Yeah. With honor, good faith, and clean hands.
Absolutely, mate. Mark, thanks again, man. We'll finish it
there.
there.
Okay, Brian. Cheers.
Speak soon.
Okay, bye.
Bye-bye.